Good evening, everyone. We welcome you tonight to the New York Academy of Sciences Anthropology Section's Distinguished Lecture Series for 2021-22. We're so pleased to launch our series this evening with Dr. Sameena Mulla and Dr. April Petrillo. Our theme for this year is emergent care and community. In the wake of our turbulent and ongoing experience of pandemic pain and politics, we focus our 2021-22 theme program on theory and critique of forms of care, mutual aid, and charity. With this theme, we raise questions about possibility and solidarity in the face of entrenched social inequalities and racialized structural violence. With this theme, we honor three esteemed colleagues from our New York community whom we recently lost: David Graeber, Sally Engel-Mary, and Leith Mullins. We invite discussion of how communities develop and deepen forms of care for one another and our environment in times of crisis or under enduring conditions of suffering. How might care be reactive, adaptive, relative, and revelatory? How do emergent communities, both on the ground and in virtual spaces, stake claims to a future that expands or contracts the space of solidarity? This conversation invites discussion of the politics of humanitarian efforts throughout the world in recognition of the reality that much community-based care emerges in the shadow of dysfunctional governance and the corruptions of neoliberalism. The global pandemic has highlighted the irony that care workers are often underpaid or even unpaid, their exploitation a symptom of structural inequalities accrued across generations. Against the centrifugal forces of capitalist modernity, what possibilities exist for radical mutuality in the future? What constitutes care as related to the social, environment, ontological, or material? Rather than asking anthropologists to assume some kind of prophetic role, this series offers an opportunity to take critical stock of what tools and perspectives our discipline provides in terms of methods, theory, community engagement, and public commentary, as we envision and imagine new possibilities for reshaping society. My name is Stephanie Rupp, and together with Christina Baines, we are the co-chairs of the anthropology section of the New York Academy of Sciences. And I would like to invite our board members, Christine Hagel and Christina Baines, to introduce our speakers for tonight.
Thank you so much, Stephanie. And welcome to everyone. Thank you for joining us tonight. We're thrilled this evening to have Dr. Sameena Mulla here to give the inaugural talk in the 2021-2022 Distinguished Lecture Series. And before I turn things over to Dr. Mulla, I'd like to share a bit from her impressive resume because it illuminates why we extended an invitation to speak as part of this year's series in which we focus on themes of care and community. She has made notable and brilliant contributions to our discipline on these areas of concern. Sameena Mulla is Acting Associate Professor of Women's, Gender, and Sexuality Studies at Emory University. Her work examines the intersections of legal and medical approaches in US interventions into sexual violence and the ways in which they are invested in regimes of gender, race, and power. In particular, her research maintains a focus on the ways in which healthcare, law, and policing configured sexual violence as a social and political wound. In 2017, she was recognized with the American Anthropological Association and Society for Applied Anthropology's Margaret Mead Award for First Book. And that book was The Violence of Care, Rape Victims, Forensic Nurses, and Sexual Assault Intervention, which was published by NYU Press. The book was also awarded an honorable mention in the Eileen Basco Prize competition, recognizing works making significant contributions to scholarship on gender and health. The Violence of Care examines emergency room-based sexual assault intervention in Baltimore, Maryland, showing how therapeutic projects and investigative goals are conflated and complicated in forensic nursing examinations. Her second book is a collaborative ethnography with Heather Hlavka entitled Bodies and Evidence, Race, Gender, Science, and Sexual Assault Adjudication. It's being released next month, also by NYU Press. Congratulations, I'm so excited for it. And the book follows the evidence collected during forensic examinations to stages of adjudication, this time in Milwaukee, Wisconsin, felony court. The book reveals that while questions of justice are often left unresolved, the science of the courts contributes to collective investments in and material production of gender, sexuality, and racial hierarchies. In addition to these valuable book-length contributions, Dr. Mulla has published in journals such as Medical Anthropology, Law and Society Review, and Gender and Society. And notably, in collaboration with NIAS board member Donna Ian Davis, Mulla is the co-founding co-editor of Feminist Anthropology, the official journal of the Association of Feminist Anthropology. She also serves on the editorial boards of Cornell and Fordham University Presses, among other service to the field. Dr. Mulla is currently working on two projects. First, studying the role of civilian oversight of policing following the intertwining and frictions between state-sanctioned forms of civilian oversight and community-driven interventions based in abolitionist social movements. She's also writing and thinking about punishment, surveillance, and disciplining in sex offender sentencing hearings. We are so excited to hear about some of this work and thinking this evening and how it can expand our understandings of how systems stymie the forms of care people need to thrive. I have known Sameena since we met in a graduate student workshop hosted by the Law and Society Association. I believe it was 2006, if I'm not wrong, when we were both fresh from our dissertation field research endeavors, and I'm amazed and inspired by the work you've done in the intervening years. I also have a personal note to pass on from Donna and Davis, who's teaching at the moment, but wanted us to send the following message before your talk. She says, "I'm so sad that I'm unable to present tonight, Sameena, but I thought I would send this message to let you know how much I appreciate you. When we met several years ago, I could not have anticipated how intertwined our lives would be, nor did I know how exciting it would be to work alongside you as a co-author and co-editor of Feminist Anthropology and a co-conspirator of Doing Good Things. You are a brilliant and generous colleague and friend, and as Heather Hlabka, co-author with you on your recent book, says, anyone who has the privilege of working with and knowing Sameena understands that she lives and breathes care. She brings care and compassion to her scholarship, to her teaching and service, to her communities, and deeply to her relationships. Sameena embodies this care in all that she does, and we are all better for her research and her advocacy commitment to critical, transformative work on sexual violence. Sameena, some people make the world a better place to be, but you, my sister and friend, not only make the world a better place, you make those around you want to do better and be better. I adore you." So with those kind words, I will pass things on and let us get started. Thank you.
Hey, so to provide a seamless transition and conversation between Dr. Mulla and Dr. Petillo, I have the great honor of introducing Dr. April Petillo. She is an assistant professor of public sociology, concentrating on gender, sexuality, race, ethnicity, political status, and culture at Northern Arizona University. Community social justice inspires April's interdisciplinary work, weaving together Native American, Indigenous, comparative critical, ethnic, gender and sexuality, socio-legal, critical trafficking, feminist, and queer studies to reconsider lived experiences often overlooked. April focuses on exploitation originating in settler colonial and conquest logics of how targeted communities embody and harness resistant joy. Her primary projects highlight legally encoded racial, gendered, sexualized politics and multifaceted coalition building. April is committed to public-facing scholarship informing societies in which we can thrive. April has given numerous talks, workshops, published articles in Frontiers, Feminist Anthropology, and Women's Studies in Communication, and written columns in academic association newsletters and resource blogs. April co-authored Rendered as Political Pawns, Chibok Girls, Ebola, and the Exercise of Political Will with Jane Eggers for Negotiating Patriarchy and Gender in Africa, Discourses, Practices, and Policies, edited by Igodi Ichendu and Ngozi Idegu. Future publications include Researching Gender-Based Violence, Embodied and Intersectional Approaches, which is coming in the summer, of 2021. Maybe it came, or maybe it's still coming at the end of summer. Co-edited with Heather Flocka, a chapter interrogating settler colonial race and racism evident in current Indian country legal interventions. Further projects include defining slaving culture, byproduct of statecraft stemming from state-produced racial violence related to the refusal to exercise political will, and a collaborative text on the sometimes consumptive nature of academic spaces. Thank you, April, for joining the conversation today. We're very privileged to have you and your perspective in this forum. So we look forward to the conversation. And with that, I believe, Sameena, you can take it away. Thank you so much.
All right. I am so grateful for this invitation. And also, that was just a really generous and lovely introduction. And I have known Christine for, over a decade now. And it's lovely to grow up together as anthropologists and thinkers. And those were just really generous introductions. So I'm a little, I feel cared for and moved. So thank you to the anthropology section of the New York Academy of Sciences, and especially Stephanie Rupp and Christina Baines and Baird Campbell, who is orchestrating so many things behind the scene, and to Christine for reaching out with the initial invitation, and to Donna Ayin Davis. So I typically shy away from content warnings, but I have been working on the anthropology of sexual assault intervention for about 2 decades at this point. And I want to share with you that I do find my own content unsettling. I find it unsettling after all of these years. So it is human and normal to feel unsettled by this type of work. I will not be including any details about sexually assaultive acts this evening, but I will be quoting racist speeches from within the courts and some actions. And there is going to be one description of by a judge of an act of physical battery of a young woman by a young man. So take care of yourselves. I have to figure out how to toggle my screen here. Okay. So tonight I wanted to talk about care clearly within the broader purview of this lecture series as a carceral object, shifting gears a little bit to think about something that is scrutinized and claimed and actually assessed by the court. While some work has gone into thinking through care within carceral settings, here I'm going to think of care and how it is claimed, who claims it, how it's weighed, valued, and projected into uncertain futures prior to incarceration. In the anthropological consideration of care, many of us have been skeptical of what Miriam Tickton has characterized as the lived consequences of the state mobilization of care. And in my book, The Violence of Care, you can see that I took this approach as I worked through the ways in which care for sexual assault victims as patients in the emergency room setting shifted from coercive to cruel to harmful, is sometimes withheld, is often experienced alongside uncaring forms of racism, is alienated, and is always disciplining. But today I want to turn to another aspect of the state mobilization of care, which emerged during my recent project in the courtrooms of Milwaukee, Wisconsin, where I worked collaboratively with my co-investigator and partner and friend, Heather Flocka, and our research assistant, Amber Powell. And this is the basis of our courtroom ethnography. That is the one that's coming out in November: Bodies and Evidence, Race, Gender, Science, and Sexual Assault Adjudication. And I don't know why my screen is being unwieldy here in terms of the slideshow, but here we go. So in the courts, what I observed is that the care of others, and by this I mean a racialized other, and regarded with suspicion, while the state, in the person of the judge and its other agents, claim the authority to provide optimal care. And again during sentencing arguments, judges and attorneys would evoke the figure of a deficient community that cannot care for itself. These courtroom logics mirrored culture of poverty arguments that have long been proven problematic and inaccurate. And I'm going to quote here a very old perspective on culture of power criticism from Carol Stack in All Our Kin, where she says culture of poverty theories explain the persistence of poverty in terms of presumed negative qualities within a culture: family disorganization, group disintegration, personal disorganization, resignation, and fatalism. This is her characterization in the late 70s. And I find that, and I think you'll hear traces of this same theory operating in contemporary Milwaukee courts. Now, I've come to this work after years of sitting in the courts, which followed years of sitting in clinics. And what emerged in the courts was, in one way, what Nicole Gonzalez Van Cleve has called a ceremony of racial degradation. But it's one with a particularly gendered valence and a distinctive anti-Blackness that is rooted in forms of evaluating care. So who do we see in Milwaukee's courts? And I apologize for all these tiny numbers, but I will summarize. Many of us are very aware that sexual violence occurs within communities in the United States, oftentimes within families and within intimate spaces. And those of us who pay attention to statistics already have a sense that sexual assault is not what we consider a highly racially stratified crime, right? And by that, what I mean is there's really not any evidence that sexual assault takes place significantly more frequently in Black communities or Latino communities than it does in white communities. But we do know that policing of Black and Latino communities is more intensive, that Black men in Milwaukee County especially are more likely to have contacts and stops and arrests and charges, which puts them more squarely under the surveillance of the police. And I mention this because what happens when you do research in a court like the Milwaukee County Circuit Courts is that you almost exclusively see people of color being prosecuted and charged. And the large majority of these are Black people. And this means that the people who are then ordered and produced in the courts to testify against them, including the victim witness, are also Black people. And in the case of the victim witness, primarily Black women and girls. And the court personnel and all of the attorneys are almost exclusively white. So who do we see in the courts? Our research team observed proceedings involving 364 distinct people being prosecuted. And of these 364 people, what this chart tells you is that 206 of them were Black men and women. And that's over half. It's almost 60%, 57% to be exact. Now, the county itself is 26% African-American, and that means that Black defendants are overrepresented, right? Twofold when it comes to the demographics. And on the other hand, again, out of those 364 people, about 86 of them were white men and women. And that's about 24% of the defendants. And guess what? The county is about 51% white. So that gives you a sense of how lopsided it is, what you see in the courts when you work in the field of gender-based violence and you understand that it's happening in all kind of racial and ethnic groups in the city. So to be in the courts became very obviously a way of being conscripted into a particular form of racial spectacle. And in our book, Heather Hlavka and I spent a lot of time detailing many of these scenes of spectacle. For example, the twice daily march of Black men in orange jumpsuits plodding in unison from the jailhouse to the courthouse, just in the main hallway. There's no separate spaces for them to navigate, shackled ankle to ankle, and paraded by sheriff's deputies for all to see. And in the book, we also work through the court's requirement that Black women and girls produce a spectacle of suffering as they testify before the courts about the harms that have befallen them. But today, I want to turn to a different dynamic, And that's the way in which the court, through the sentencing hearing, generates a racial spectacle that focuses on the inadequacies of care in the worlds of the men they are sentencing. And I want to emphasize here that in drawing attention to the ways in which the world of the person being prosecuted cannot afford the care he needs, the court simultaneously draws attention to the world that his family, his neighbors, his kin, his friends, and most often the victim in the case also occupy. And I'm going to argue that he's a conduit to these other people and these institutions. So returning to my field notes on the 190 sentencing hearings I sat through, they followed a very structured form of discourse that people who've been in criminal courts would be familiar with. And this is a tripartite formula through which the judges invoked punishment, safety of the community, and rehabilitation. And in considering rehabilitation, oftentimes the defendant emerges as a therapeutic subject. But there is also an assessment of community-based resources that would be a part of restoring this person to being a productive, very much in a capitalist sense, part of the community. The rehabilitation of this person was seen as rooted within those community infrastructures. And when a sentence required in-custody incarceration in a prison or sometimes a jail, the infrastructures of the community had to be degraded and deemed insufficient features of an ecology of rehabilitation. And part of what we heard during the sentencing hearing was very specific assessment in which all of those infrastructures, all of those institutions were deemed deeply flawed, pathological, unproductive spaces for a person to heal in. So that left the judge with no choice but to say that this person can't be rehabilitated within the community and they must be incarcerated. And I don't have a slide on incarceration rates in Wisconsin, but Wisconsin and Milwaukee especially is an area of the country that is frequently pointed out as experiencing hyper incarceration of Black men and boys. And it's quite intense. So how do we get there? What are the mechanisms of only being able to, no matter what the set of circumstances in front of you, commend a person into in-custody care? So begin with, the court often would establish that the person being sentenced was himself incapable of taking care of himself. So for example, I'm going to share with you some words from a defense attorney. So this is the client's own attorney. And I call the client in this case, Mr. Wilson. And Wilson had just actually been released after serving a 15-year-long term. And this case came about a few months later, and he had just pled guilty to charges of exposing a minor to a sex act. And here's what his attorney said during the sentencing. Your Honor, I agree with the state. This is a prison case, primarily because Mr. Wilson has a prior record and should have known better engaging in this type of conduct. I'm asking the court to consider 5 years globally, 2 in and 3 out. I think that would be enough punishment and time on extended supervision for him to get treatment. He tells me that when he was in prison, he did not get sex offender treatment. The pre-sentencing investigation indicates on page 5 that he was released from prison without the benefit of sex offender treatment. It appears it wasn't ordered for whatever reason by the court, or the Department of Corrections didn't have a program available for him. He's low functioning and would require that. I think I have that now. Hopefully when he gets out this time, he'll have the benefit of that. I think just as important, he needs a serious look at his alcohol use. He tells me that the entire time he was interacting with this girl, he said he was drunk all day, every day, was drinking from morning until night. And it's, you say, geez, you should exercise better judgment. You should be able to tell when this girl says she's 18, she's really not. But when you're drunk all day, it's hard to be able to do that. So he's got a really serious alcohol abuse issue. And he tells me that it's so bad, he probably is going to have health problems around his liver and other issues that he's going to have to deal with. I don't know if he doesn't make change in that area, how much longer he's going to live based on what he tells me. So I think prison is appropriate. So here we can see the defense attorney made the case for a 5-year sentence in which Mr. Wilson would serve 2 in custody under the premise that Wilson was unable to exercise good judgment or restrain himself from abusing alcohol. He also referenced sex offender treatment and pointed out that during Wilson's last period of incarceration, he did not access this treatment. He was vague about why the treatment never took place, but suggested that more prison time would give Wilson an opportunity to participate in sex offender treatment and also to deal with his, quote, alcohol abuse issue. The defense attorney painted the alcohol abuse issue as potentially life-threatening. And in this setting, incarceration is lauded as life-saving, and the judge concurred, sentencing Wilson to, in fact, a 6-year sentence, 3 in custody and 3 under supervision. A second topic commonly discussed within sentencing hearings was the defendant's history of employment. Employment served as an important marker of one's ability to conform to traditional masculine social roles and to demonstrate what the court recognizes as pro-social behaviors. In the excerpt of a hearing that follows, you will hear a judge expand the scope of inquiry to condemn the defendant's former employer. When a defendant who I call Mr. Steele, when his attorney, who is a Black woman, and this becomes relevant later in the scene, pointed out that her client's successful history of employment was a factor suggesting his ability to be rehabilitated and conform, here is how the colloquy unfolded, beginning with the judge asking what the job had been. The attorney responded, he was working as a driver for a daycare van. The judge said, so let me get this straight. Some daycare in the city, God forbid, hires Mr. Steele, who is a convicted felon, who has auto theft on his record. That would be problematic if he was to steal the van that he's driving with kids in it. What ridiculous daycare hired Mr. Steele, violating, I'm sure, their moral duty, if not some legal duty of the state? And then turning to the defendant, the judge asked on the record for more details of that former employment. He said, who were you working for? And these names are all made up, but I tried to preserve the spirit of the back and forth. And so he responds, Angel Daycare. Angel Daycare, what on God's earth is that? That is some half-baked, unlicensed storefront daycare, right? It was a real daycare. And I checked, and it is indeed a real licensed in-home daycare in a predominantly Black and Latino neighborhood in Milwaukee. But the judge continued, a real daycare run by who? And the defendant responded, Rainbow Smith, that was the owner. And the judge snorted, Rainbow Smith. And you could hear that kind of disdain in his voice over the name. That's her real name, Rainbow. Of course, good God, people cannot believe what I see. There should honestly be a camera in this court every single day. So we have a convicted felon working at the Angel Daycare who was hired by Rainbow, going with the theme, God save us all. Go ahead. Now, there's a lot of things I can point out in this back and forth, but referencing the camera in the court suggested that the judge was aware of the spectacle of the hearings that he's adjudicating, that he invited a collective gaze on that racial spectacle in the court. And as the hearing continued, the judge then incorporated Steele's attorney into the rapport. After Mr. Steele explained that he was, quote, basically a nice guy, the judge contradicted him by announcing, basically, Mr. Steele, who is 30 years old, is a lawbreaker. Contrary to popular belief in some segments of this community, it is actually possible to reach the ripe old age of 30 without going to jail or prison. For instance, and he turned to the attorney, Ms. Hunter, you're young, you're probably not even 30 yet. But have you ever been in jail or prison except as a visitor? It's really hard to imagine this scene playing out with a white attorney, but here goes the judge. And the attorney responded, no, and I'm over 30. And the judge responds, I've never been either. Mr. Steele, you're a lawbreaker. You're a bad actor. You are someone that I need to take out of the community, because when you're in the community, you've done poorly on probation previously. You've been revoked previously on more than one occasion. You know, when you say you're a sweetheart, that's hard for me to believe. Big, sweet teddy bear kind of guys don't punch and beat on women. See, in the old days, men wouldn't hit women. That, like all kinds of morals in this community, has gone the way of the dinosaur. It is in these small moments, the expression of disdain for a name that is normalized within Black naming conventions, or in his inability to correctly guess the age of the Black woman attorney before him, or even to assume that a licensed, experienced attorney would be over 30 years of age, or in the careful use of the term community as a proxy for race, or more precisely for Black communities, that we saw the court both dance around naming Blackness outright, but also we saw the judge's lack of familiarity and the cultivated disconnection from Black social life. Additionally, the judges claim that certain, quote, segments of the community see arrest and imprisonment as an inevitability, draws parallels with the culture of poverty arguments around resignation and fatalism. When he attempts to recruit Steele's attorney into his critique by asking her about her criminal justice history and contacts, he's demonstrating which segment of the community he's mobilizing. And as I said before, had Steele's attorney been white, it is, I think, reasonable to surmise the judge would not have asked them about their history of police contact and arrest. And then the judge ends with a revisionist history of a past in which men wouldn't hit women, which I, cheekily assume are the glory days, perhaps, when domestic violence and marital rape were not criminalized. So they never drew the type of public scrutiny they do now. And then he moves on in describing the defendant's behavior back to him and reproached, I mean, seriously, Mr. Steele, that is uncivilized behavior. A civilized 30-year-old, male or female, Black, white, Hispanic, Hmong, Chinese, Italian, whatever ethnic group, does not behave that way. Almost catching himself in the act of suggesting Black communities are uncivilized, the judge made sure to specify that his accusation of being uncivilized was a standard applying to all races, cultures, ethnicities, and genders. Well, this case and this particular judge made it a point to condemn the inadequacy of the daycare that had previously employed Mr. Steele. In another case, the district attorney spent a great deal of time explaining the limitations and deficiencies of a defendant's partner. So in that particular case, there are two victims, and both of the victim witnesses are the daughters of the defendant in this case, of the defendant's partner in this case, rather. And I call the defendant Mr. Green, and I call his partner Lakeisha Green. And here we have the district attorney now talking during the sentencing hearing about the facts of the case. And she said, the defendant was dating or married to Lakeisha Green, which the court may have noted from his adult criminal record because 3 of his 4 convictions involve her. She is somebody who's had, and I don't know if she continues to have, but she had in the past a drug and alcohol problem. She was the victim of Mr. Green physically. She has been involved in the bureaus, and by that she means the Bureau of Child Welfare before, and has had her children taken away and placed in foster care. So she's not somebody who's eager to be part of the system, I would say. And based on her previous drug use and her victimization by the defendant, I think she is, and what happened through the child welfare system, which was all necessary, but I think this has made her afraid of the authorities and frankly, afraid of Mr. Green. Later, as she explained why the disclosure from both of the victim witnesses was delayed, the DA noted that one of the girls, who I call Serena, had told her mom, and her mom, this is a quote from the DA again, told her not to tell because her mom would get in trouble and all her brothers and sisters would get in trouble and all her brothers and sisters would get taken away because that's what previously happened. So Serena, this is the DA continuing, with the mom putting essentially the weight of all of this on her because the Bureau would take all the children, and that is what was the experience in the past, Serena didn't tell. A horrible place to put a 7-year-old in, and Ms. Green probably is not going to win any awards. And as the court has said in the past, she has limited parenting skills, is a nice way of putting it. But Serena kept this all in and didn't tell. I don't think that was so nice, personally. This hearing was one of many in which comments were made about Black maternal figures, and while Blackness was never named, it was clear whose mothering was deficient. Later in this same hearing, the DA lamented that neither of the 2 girls had shown up to make a victim impact statement. The older girl, she commented, would have impressed herself on the judge as a, quote, very articulate girl. I want to draw on one more case in which the judge we heard from earlier, who complained about Mr. Steele's uncivilized behavior, roundly critiques all of the nurturing forces in the life of a young man I call Travis Horton, who's 19 years old. Young Mr. Horton was one of the few people who received a probationary sentence, though he was in custody for 6 days in the county jail. With no criminal record and his charges reduced to misdemeanor pleas, it was still critical for the judge to evaluate the deficiencies in Mr. Horton's support system in a packed courtroom and on the official court record. Invited to address the court, the back and forth began with Mr. Horton apologizing. Your Honor, I would just like to say that I'm sorry for what I've done in the past, and I would like to apologize to the victim and her family, and I'm looking forward to doing better. Mr. Horton, are you working? I'm trying. I have to wait until my ID comes. How can you be almost 19 and not have an ID? Because my ID is in Chicago. My birth certificate is in Chicago, and my mom just sent for it. Where does your mother live? She lives in Milwaukee. So why is your identification in Chicago? Because she used to stay in Chicago. And she didn't bring it up with you? What, it was too heavy? So what are you doing with your time right now, Mr. Horton? Are you basically hanging out? As the hearing continued, the judge asked Horton why he had physically assaulted his girlfriend, who is the victim witness in this case. When Horton responded that they'd gotten into a fight over how to spend Sweetest Day, the judge responded, "This is just another one for the book that I'm going to write." So first there should be televisions and the cameras in the courtroom. Now there's a book he's going to write. Mr. Horton, that may be the dumbest, stupidest thing I've ever heard in the last 4 or 5 years. And believe me, that takes in a lot of bad behavior. So honey, do you want to go out for a walk in the park and a nice ice cream cone? No, I'm not in the mood, okay? You bang her head on the table. This is another case where this community is so far gone. I've got to leave. I've got to move to Montana or somewhere else. The behavior in this community is so uncivilized, it's unbelievable. And Mr. Horton, I hate to ask because I'm sure I'm not going to like the answer. Do you have a father in your life? I have a father, but he's not in my life. Where is he? In Chicago. Doing what? I have no idea. Lovely. And what does your mother do? Does she have a job or what does she do for a living? She takes care of old people. Are you still living at home? Yes. See, Mr. Horton, if you had a decent father in your life, what your father should have done upon finding out about this, he should have kicked your butt from one end of Milwaukee County to the other and then locked you in the basement. But you don't have a good father. And since your father is not around, your mother should have done the same thing. Kicked your rear end from one side of the county all the way to the other, and then lock you in a basement without a TV, without an Xbox, without cable, without a Game Boy, because you're a bad actor. And when it comes to your graduation, I could get started on this topic. You graduated, if you want to call it that, from Central High School with a 0.8 GPA on a 4.0 scale, ranking 283rd out of 317 at Central, which has never been confused with Harvard or Stanford, never been confused with even Rufus King or Marquette. So in other words, you graduated because they were sick of seeing you. And they said, see you later, here's your diploma, congratulations. And Milwaukee Public Schools put out another child in Milwaukee County who can't fend for themselves, can't or doesn't have any employment skills, and will probably be a drain on society. That structural critique should have scare quotes around it. But this last comment by the judge, whose irritation now turned to the Milwaukee public school system, an underfunded and overwhelmed public school system that is serving the largest group of children in the state, the majority of whom are qualified for free school lunches, and the majority of whom were Black children, a school system that I should say is reimbursed on a per student rate at lower rates than every other locality in the state of Wisconsin, was perhaps the closest the judge came to making a systematic critique of a systematic failure that was disadvantaging Milwaukee's Black communities. But stopping shy of connecting these dots, it's not exactly clear what factors he attributes the failure of the school systems to. Once again, he had impugned Horton's entire network of care, the failures of maternal care in the defendant's network. He insulted his mother's ability to produce required documents for her now adult child, and admonished her for not, quote, kicking Mr. Horton from one end of the county to the other in the absence of his father. Now, in 1965, in his infamous and influential report titled The Negro Family, the Case for National Action, Daniel Patrick Moynihan asserted that for vast numbers of the unskilled, poorly educated city working class, the fabric of conventional social relationships has all but disintegrated. Clearly, there were eerie shadows of this disavowed evaluation saturating the discourses of sentencing hearings. The stickiness of this anti-Black logic clung not only to the person being sentenced, but my fieldwork and those of my collaborators and the court transcripts that we collected are replete with many more examples of the ways in which sentencing hearings become a trap for all of the people in the social world of the person being convicted. The victims, lovers, wives, partners, girlfriends, mothers, employers, educators, pastors, many other kin and relations were often the subject of scrutiny, scornfully dismissed or deemed inadequate. The sentencing served as a conduit into the social world of the person being convicted. And the fate of the, quote, sex offender was then sutured to the future of Black communities with which he was associated, who were themselves disciplined through the sentencing hearing. This is how the state sent its tendrils deeply into the very fabric of Milwaukee's Black social worlds, expanding its carceral reach and institutionalizing the condemnation of Blackness. If in the late 1960s in her fieldwork in the urban Midwestern city that Carol Stack calls the Flats, she, quote, became poignantly aware of the alliances of individuals trading and exchanging goods, resources, and the care of children, the intensity of their domestic cooperation, and the exchange of goods and services among those persons, both kin and non-kin, unquote. This talk has sought to show that the sentencing hearing serves to disavow those intensities of care and kinning. I want to end with a callback to some insights from anthropologist Amy Meredith Cox. Her interlocutor, Janice, a young Black girl in Detroit, recognized the dangers and difficulties of the ways in which institutional narratives are missing the middle. When Cox asked Janice to explain what missing the middle meant, Janice explained that it is the way we always have to think about how other people see us and compare it to how we see ourselves. Scholar Farah Jasmine Griffin writes that, quote, Janice describes a kind of Du Boisian double consciousness in which Black girls are fully aware of the ways that dominant discourses define them, unquote. In Cox's ethnographic meditation on what she terms shapeshifting, shapeshifting is a description of how Black girls might create possibilities to evade the ways in which social service institutions attempt to shape them into, quote, manageable and respectable members of society. My own work has brought me to recognize the ways in which these social service institutions are extensions of the carceral logics of the criminal justice system. And when Cox describes the social meanings that are shackled to young Black girls, I hope that I've shown how the state conducts this shackling through the Black men who have been convicted of sexual assault, even as the courts make claims to protect Black women and girls whom they invoke as the community in whose name they punish and imprison. And I just wanted to end there, and I'm going to thank Heather Lafka and Amber Powell, who are two of my collaborators who I think are here tonight, and the National Science Foundation for funding the work, the Women's International Study Center, where a lot of the thinking around this has been done, and April Petillo, who is going to describe, and when Cox describes the social meanings that are shackled to young Black girls, I hope that I've shown how the state conducts this shackling through the Black men who have been convicted of sexual assault, even as the courts make claims to protect Black women and girls whom they invoke as the community in whose name they punish and imprison. And I just wanted to end there, and I'm going to thank Heather Lafka and Amber Powell, who are two of my collaborators who I think are here tonight, and the National Science Foundation for funding the work, the Women's International Study Center, where a lot of the thinking around this has been done, and April Petillo, who is going to be in conversation with me now.
Well, I just want to take a second to say thank you for this lecture and this talk, Sameena. It has been very thought-provoking and producing, and also angering. And to thank also NIAS's anthropology section for coordinating the series. because it does seem crucial to evaluate and critically critique the care, mutual aid, and charity we engage at this time. Addressing social inequity and racialized structural violence on multiple fronts is both daunting and necessary to surviving pandemic times and the aftermath somewhat intact, as well as reconciling who we want to be in that process and thinking about who we have been beforehand. So with that in mind, this is kind of a broad question that I have for you. So I'm really struck by the ways that you've illustrated intersectionality and the resulting impacts. And I know that before we've had conversation at other times about how people talk about intersectionality as, a combination of identities. That's become the shorthand. But it is important to remember that it comes out of legal theory, which means it's thinking about the ways that these structures that we live by, and for some people represent our morals, respond to these categories. So it's an external understanding of identity imposed on people using the same language that they might use for their internal understanding of their identity. And in tonight's talk, you've woven together how these structural labels that are shackled on to Black men as bad actors transforms them, on one hand, into a tool by which at least one state objective can be met, denigrating Black kinship and shape-shifting for survival in a hostile system as something that's just unintelligible, unimaginable, unproductive. And on the other hand, Black men become a symbol for justifying anti-Black state hostilities, as you illustrate beautifully in your description of the interaction with Mr. Horton, talking about how his parents should have been violent towards him. So broadly speaking, what adjustments do you see if these kinds of courts, even this kind of judge, move away from responding to Black men as tools and symbols, and instead move towards treating Black men as varied, complex beings with human realities?
It's a very thoughtful question, and I have a very cynical response at this point, just because I often talk with my interlocutors and my collaborators about what it's meant to sit in the courts and hear all of this and see it all unfold. And then even these last 2 weeks where I sat down again and, reread 190 sentencing hearings that I sat through maybe over a year and a half, but all in 2 weeks. And just, the weight of them and the poisonousness of them, I really started to see that what my records are kind of fragments of courtroom records, right? There's an entire archive here that has to be unsettled as well. And it's a living archive, right? A court record, a precedent, is one that has this very deep weight and force, and it has a certain volition. So the type of interruption that would be required, right, I think is not possible within our criminal justice system as it stands. It's, Milwaukee is an interesting place. Time and again, people have talked about restorative justice models. Our chief judge is currently reading Daniel Sered's book right now, and, capable of having really interesting discussions about what it means that people are complicated and do bad things and can be held accountable in complex ways, right? Mm-hmm. And that accountability is very important to me, but it's more important to me to follow the lead of the people who are harmed in crafting, what it means to achieve some form of justice and reparations and healing, because there's more sequelae of harm. If we think about Kristen Smith that just kind of repeat themselves, in the worlds of the women and girls who've already been harmed following these sentences, even when the person who's been harming them has been kind of removed, right? They might be free from the harm of sexual violence, which is something that many women do want, women and girls want. But, even the ending scene of the book that Heather and I have just written, we kind of return to this woman pleading with the DA, please just put him on probation. This is a woman whose partner has harmed their children, and she doesn't want him in the home with her and their children, right? That's very, very clear. She has participated in testifying against him. She's really walked a really difficult ethical path and made some hard choices to protect her children. And at the same time, there are 5 children, and he's the primary wage earner. And so she knows what's coming, which is that his labor is about to be divested from their household. And so sometimes I think, if there's a reform, like, why can't people who are being disciplined be allowed to continue to make a living wage so that they can continue to support the people who are still economically dependent upon them? And in that ethnographic scene that Heather and I write about, the woman is pleading with the district attorney, who's a white woman, who kind of gives her, like, she puts on temporary blackface basically and gives her a little sassy girlfriend talk and is like, sister, you're going to be okay. And I was in the hallway watching this, and I was like, you can't promise her that. She's not, right? Because precisely this system doesn't afford any of that. So I think it's possible to meet people where they are. And I think if we're talking about the Black men whose harms, they've perpetrated harms, right? There's a complicated issue here where, the harm that's happened is real, but it's also being tied to these like really deep narratives around, the Black rapist, they're old and powerful, right? These fears are being mobilized. I think the people who see that harm most clearly are the people who have been harmed. But I don't think that perspective or that set of that work of repair would necessarily come from within institutions as they currently are.
That's a really good point. I mean, I don't know that I would characterize that as cynical. It sounds very deeply rooted in the ways that the current criminal justice system has always operated, right? I think about how this is the response no matter what. And in my mind, it goes back to 1800s response to spotted tail, right? With basically an action that ended up with Indigenous communities saying, there is a way we would like to deal with this punishment that does not put the family in a precarious position. And there is payment and there's a process and the community is involved and creates a larger sense of justice from this criminal act. But the US government comes in and says, no, that doesn't quite work for us. And then the sense of justice is made very teeny tiny and specifically surrounds this one individual who must be punished as a symbol, right? And it sounds like what you're seeing is this continuing and existing for other communities as well. So
I'll say one little thing here. I was asked to write 10 things about truth and responsibility for the next issue of the Anthropology News, in keeping with the theme of our upcoming AAA conference this year. Mm-hmm. And one thing that does have me thinking about in terms of truth and responsibility is whether or not you can be held responsible by a community who doesn't feel like you're theirs, right? Mm-hmm. I mean, And in these sentencing hearings, I think that there's so much work being done to expel this individual and to expel the communities in which they're embedded, right? There's no claiming. And so I don't see any possibility there, right? I really do think accountability has to unfold in a setting where we belong to someone, right? And we belong to each other. And, whether we do unsavory things or not, right? Someone makes a claim to hold us accountable.
Yeah. Well, there's accountability, and there's also creating safety. How can you create safety for people that you think are not possible or not capable of creating care that's effective? I saw in the chat the comment, accountability requires community. Absolutely. You must, even if you're not of that community, you have to be willing to be in community to really do that in a humane way, right? I'll also say I was struck by your exploration of the idea of what became in my mind the parade of racialized spectacles. And some of what you've named is what I think of as the spectacle of captured monstrosity in the shackled men heading to trial, the spectacle of suffering Black women and girls during trial, and a sort of spectacle of inadequate care worlds or networks that's purposely situated as Black, and it's rhetorically and physically invoked by non-Black court personnel. And I really think you're onto something with that in terms of illuminating the ways the courts double speak, perhaps enhanced by these spectacles, by focusing on the wrongdoing of this monstrous individual who's a stand-in for the community, a link to the community. The state and the court don't have to acknowledge the work that's put into creating the spectacle, nor do they have to acknowledge that that spectacle creates specific vulnerabilities that create a need for a benevolent state to take care of things. So in my own work, I think about this and talk about this as statecraft, and a sleight of hand that's involved in statecraft to distract people with one thing while in the back you're being the Wizard of Oz puppeteer. How do you think this idea of statecraft might operate additionally in the scenes that you've seen throughout the work that you've done, from the clinics to the courtrooms?
There's so many ways to dive into that one, and I'll pick up a couple. So I think one thing that's really important about fieldwork and ethnographic methodology is how patient we are. So, if you're trying to catch the wizard behind the curtain, right, the longer you wait, the more likely you are to see those slips. Mm-hmm. And I really think that's something that, has come up in the fieldwork because of our patience. So I think one of the things that's really kind of takes my breath away is the way each hearing, each trial, each sentencing, right, is its own kind of separate, whole unit. But if you sit in the court all day and you watch 10 different hearings in a row, or if you sit there for a year and a half and you're not just alone, you're one of 3 people, you really start to pick up the moments where the state's showing its hand, right? Mm-hmm. So, I give this example that, here we have somebody who's just gotten out of prison after 15 years, and clearly prison's going to repair him. I mean, that's the failed experiment that's already taken place. But for some reason, we have to reproduce this notion that he's inadequate to his own care and the prison is the place for him to heal. He didn't heal in 15 years, right? Ostensibly, but somehow this next 3 years is going to do it, right? And there are many moments like that. And there are even more egregious examples where, at the very beginning of our field research, judges for pretrial monitoring would often prescribe GPS monitoring, right? They wanted people on ankle bracelets so they wouldn't have to be held in custody. This is still a form of incarceration. It still restricts freedom, but people consider it to be, relatively less restrained than being in prison. You haven't been sentenced to anything, so here's the pretrial monitor. There were not enough GPS monitors to keep up with the demand in the courts, so people were being sent to the jail anyway. And the judges, had 1 or 2 hearings where they inquired, well, why is this happening, right? So there's also this fantasy of the endlessly resourced state. This came up another time when we were hearing people who'd been sentenced and had been given as conditions of supervision. So they were not in custody, they were under supervision. They were given treatments that they had to participate in, sex offender therapies. And so they would show up 6 months later and the judge would say, well, why haven't you started your therapies? And they would say, well, there's no room for me because there was no capacity. In one particular case, there was specifically an issue with Spanish language therapeutic services, i.e. there were none. But Spanish language speaking defendants were being given this as a condition of their supervision. And so in a few cases, the Department of Corrections officer who was supervising them was serving as an interpreter at these sessions, which were being conducted in English, right? And so this came out in the court. So there's a great deal of statecraft in terms of the state kind of painting this picture of itself as adequate to the challenge of rehabilitating sex offenders, right? And they don't see them as complex people who deserve excellent therapeutic resources. I mean, the idea of using your parole officer as a translator, if you say something, you could be revoked and sent to prison, right, in front of him. That doesn't exist in any kind of ethical framework that I'm familiar with. But there's lots of different examples like this that come up again and again and again. But if you are one person, right, involved in a case and you only show up for that particular case, you have no sense of what is the kind of global landscape in which all of this is unfolding, right? And the consequences, again, play out really unevenly across different forms of privilege. And that is, I think, much easier to see in terms of, again, patience and duration and long periods of time.
Okay. I'm going to pose another question, but I'm also trying to be cognizant of time. And I imagine there are plenty of questions that people might have. So feel free, someone, to let me know. I have a ton of questions and I'm happy to open the floor up should audience members have questions as well. So this is a conversation point more than a question, I think. So I suspect that while you were working on this talk and going through and rereading 197 bits of story here, that you were also aware of the first of 4 trials centered around decades-long reports that the R&B entertainer R. Kelly was regularly involved in sexually exploitative relationships with minors. the first trial, wherein he was found guilty of sexual exploitation of a child, bribery, racketeering, and sex trafficking involving 5 victims, ended a week ago with a guilty verdict. Now, part of, and this comes from solely my own work thinking about conquest legacies and settler colonialist logics, and how that informs state-sanctioned sexualized violence in US law. So there are some things about the legal system that I know and expect, and I'm still dumbfounded by what it took to get here. Without comment on R. Kelly's guilt or innocence, the situation in that way, what dumbfounds me is that it took the victimization of at least 12 young Black people. It took discussion in the community that began in December 2000 with an article in the Chicago Sun-Times. It took all of that for us to get here. And I feel like that says something about the value of not just Black life, but like the value of people within the system when we talk about things like gendered violence, when we talk about things like victimization and exploitation, when we talk about those things like accountability. Do you feel like there is something that you've seen or documented that might help folks understand this from a community perspective? That, you know, how does the community respond? That there are people in Black community who are still saying, well, I think he's innocent. Mm-hmm. How might that reflect community care or not? How might that be a refusal to let R. Kelly be a conduit to what's framed as inadequacies in Black care worlds?
That case is ongoing and so painful to me. And I know that for many people, the conviction is deemed a success, but for me, just 20 years is too long. So it feels like a failure. And I want to couch any response I make with some sensitivity to the fact that, like, I am not a member of those communities, right? And I believe in family business, and that, you know, we don't, even as anthropologists, we should not actually butt into family business. There are some conversations that really just need to unfold in spaces in which it's completely okay that I'm not a part, right? It's a healthy and good thing. No one owes me that. And the cases I write about, I partly write about because they're public, right? Trials are very public. Clearly, this one is very much a public spectacle. There's, you know, it has such a long, close history to the media. And so that's where I think, you know, there's room for someone who isn't part of those communities to think about how I am being brought into what this spectacle is, right? And how I am being asked to consume those things. And so for me, it's been very, very important to kind of affirm the perspectives of the women and girls who are hurt by the ongoing conversations. So if I'm invited to affirm, I do, but I don't actually see it as my place to comment, you know, on some of those tensions and harms, because I think it's really important to allow people to have those spaces to grieve and work through those series of behavior. On a meta level, what do I know? I know that gender-based violence is an intimate wound that happens within communities universally, right? And I think that one of the things that the courts and the media did is reinforce the the inability to value and care for Black women and girls, right, and lend that authority to people within those communities as well, right, and that's true to all of the communities that we belong to oftentimes. And so there was, I think, a real harm and disservice done there, and I don't know that one guilty verdict, right, undoes all of those things, because there's still very much this spectacle, and in some ways the length of the resolution is a lack of a resolution, which has now unfolded over generations, right? And so you have now very, very difficult intergenerational conversations going on. So I'm still sort of sitting in this moment where I'm trying to think about what has been affirmed by this first case coming to some kind of resolution. And I think I'm going to be sitting with that question for a while.
Okay. I see that there is a hand. I realize I'm not sure how we want to address that.
I can actually unmute myself.
Okay.
Since I started. So thank you so much for this incredible talk and for sharing with us so much of the thickness of your ethnographic research, Sameena, because I do feel like it really has given us something to consider in light of your analysis, and to pose questions about in and of itself. And one of the things that sticks with me is the description that you have of the judge evaluating and casting aspersions on the behavior of the defendant's father, saying he was a terrible father, he should have done this, he should have done that, and he didn't do any of these things. And so in a sense, he's adjudicating the care, the parenting of this father. And I guess my my understanding of sentencing hearings is that there are ways in which the background, the family background of a defendant may be brought into that sentencing hearing, right, productively, in order to make an assessment that takes into account some of the life factors, the familial factors and so forth that may have contributed to their behavior. In this case, that's not what's happening. And I'm wondering, it makes me wonder whether or not, like, what kind of accountability exists within that professional domain for a judge's use of that their adjudication of, something like that the defendant has no control over. Obviously, they had no control over how they were parented and what their father did and didn't do. So is there any process or system by which judges are reviewed and this kind of discussion is at all articulated as inappropriate? Does that ever happen? Is there any framework for that?
So all felony cases automatically get reviewed by the appellate division of the public defender's office. But the case that I read from with Travis Horton, right, that actually does not rise to, it begins as life as a felony case and then is amended down and he pleads to some misdemeanors, right? So that one will never be reviewed. These transcripts often never get written out. They exist only, again, for the felony trials, guilty pleas, those will be reviewed automatically by the public defender's office. But this, the only person who asked for the hearing transcript was me and my research team, right? Heather and Amber and I. Otherwise, no one else is really reading and reviewing these things. And there is recourse to complain. There's an internal standard, which is being appealed, having your sentence overturned. And I can tell you that that particular judge actually has a pretty good record in terms of his sentencings being viewed as appropriate. And in contrast with the person in that rotation who has the most appeals against him, who's very, very formal, right, and never inserts that same kind of editorializing. And there have been complaints against this particular judge, and at one point he was taken off of the sex offenses rotation and sent to a civil docket, right? And it is also a rotation that judges don't want because it is exhausting. And when you sit in that court, you hear all of the homicide cases and the sexual assault cases. And so it can be really challenging in many different ways. So after a few years, 2 head judges later, he got put back into the rotation and continues to be a sitting judge. And I will also tell you that in terms of the length of his sentences, they on average tend to be shorter than the other judges in his in that felony court. So he is often requested by the attorneys. If they draw a different judge, they will try to have their case transferred to him. And so the defense attorneys you see participating in this, they just prep their clients and they say, no, he's going to say all kinds of things because he's trying to provoke a response. And if you misbehave during the colloquy, right, that is used as evidence against you, right? You're unable to comply with the system, but they are prepped by their attorneys not to respond to any of these provocations. And so you see them kind of like participating in the continued creation of this record. So it's, judicial discretion is an amazing and frightening thing. But I think that, one of the capacities of the state that we also we sort of imagine is more capacious than it actually is the capacity for oversight.
Thank you.
Go ahead, Stephanie.
I guess since I can unmute myself, I'll do the same thing. I'm watching the chat. I'm seeing there's no one else who's trying to get in, so I'll take some airtime and ask a question as well. And it follows on the heels of Christine's thought. I'm really interested in the way in which, this is for those of us who don't sit in on court proceedings. This is shocking. Like, it's shocking to see how people's lives are trivialized. And it's shocking to see how the fantasy is played out in 2 very partial ways, right? So Jan Vancina, who is a historian of African pre-colonial times, talks about partiality in 2 senses, right? So the historical record can be incomplete, partial, and it can be biased, partial. And of course, there's a connection between incompleteness and bias. And I feel like we can see in opposite directions how partiality intersects with privilege. And so the under-resourced state, which is performing its own fantasy of authority and of omniscience and of power, you tell us is under-resourced. Like, it's a fantasy that it's a resource state because people don't have access to the services they need, and people don't have access to the language translations that they need. They don't have access to bilingual Spanish, English, right? You give us all these examples of the fantasy of the state, which is cloaked in the figure of this judge who is impenetrable, who's remote distance, probably, I'm imagining up high behind a desk, right? Like actually up. And then you have the fantasy of the recreation of the partial defendant, right? And the way the judge can pick and choose what details to extract from this individual's experience humiliate and to pose as a clone or a stereotype or a target just to be put on show, right? It's this fantasy in the other direction. And so in one sense, the partiality of the state, the judge can sort of step away from or brush off, right? As if the court is an ideal system, some kind of impartial judicial process. But the partiality of the defendant is like honed in on for attack. And so it's a very different way of, on the one hand, glossing over the failures of the state and picking at and digging into those long, historically deep wounds of people whose lives are being represented in very partial, incomplete, and biased ways, and have been for so many generations. And so it's like, I'm left with this sense of bewilderment at how incomplete everything feels. And I feel like what you're trying to do is show us the holes on both sides and to say, this is what ethnography can bring in terms of a careful, close reading of the lives of the people who are defendants and the flaws of the system that purports to be full. That's what we have to say.
Thank you. Should we also get the question from Nina Glick-Schiller?
Yes, can you hear me?
Yes.
I can put my video on too. There we go. Hi, thank you so much. I guess I'm coming from a different kind of voice than Stephanie, just because I've sat in so many courtrooms and watched this over decades, and both for immigrants and also for poor people, mostly Black. And I think it's very important to raise the questions. That was really helpful. What is this really about? It's clearly not about justice. And it is certainly about everyday forms of state formation. That's what your presentation really brought home to me. All this discussions about the state, sort of falling apart, but it depends on what you mean by the state, because the carceral state is what you're describing for today is what I saw in the 70s in Cincinnati. And then the question is, who is the audience? Because it's not just the person who's on trial. The courtroom is filled with other faces of people who are waiting for their trial. So this is the classroom in which young, mostly young Black men are being educated, and their mothers and sometimes and families. And so this is where the power of the state is being acted out and embodied, and where race is being made over and over and over, decade after decade and after decade. So and it's never been about providing any kind of resources, really. That's what all of us who don't sit in there think might be going on, or rehabilitation. So the kind of work you're doing is very important. And then it raises the question, how many more decades can we possibly put up with this? And the Black Lives Matter movement was beginning, as part of an ongoing struggle to provide an alternative vision and answer to that. And you can see why there's been such an effort to repress it, delegitimize it, and make sure it's not taught. And particularly, so I really think the struggles around critical race theory have everything to do with what was going on in that courtroom, because that's trying to use the classroom to create an alternative lesson. So I do think that I think everybody should sit in a courtroom. Both the courtroom where migrants are brought, refugees are asking for asylum, and also courtrooms, these kind of courtrooms. And as part of our education to think of the way a different world might be possible. Thank you.
Thank you. And yeah, we should all sit in courtrooms. And I will say that there's, at different stages and times in different cities, there have been court watches where, citizen observers go into courtrooms and take notes. And Christine, getting back to your question, that is one place that accountability can come from, that if enough people see something happen, you can potentially make a record of it in that particular way. Like Minneapolis has a really powerful and well-organized court watch. Milwaukee doesn't have one that's consistent. Chicago has one now. And the other thing that I was going to say is that I often think about like what it would mean to divest from these systems, right? After The Wire finished filming, the writing staff all, put out an editorial asking people to refuse to serve on juries in drug cases. And I've often thought about, I think a lot of us who are sort of exploring what does it mean to do legal anthropology, like in the courtroom on sexual assault cases, right? As someone who, I don't believe in incarceration as a solution towards better anything. It does not prevent any kind of future of harm in 99.9% of cases. And even if it does, it proliferates, other very gendered harms. And that's very clear, right? So what would it mean to sort of, divest from that system? And I even, as far back as like 2009, when we had that last real economic crisis prior to COVID, I remember like watching the courts and, San Francisco said, hey, we can only afford to stay open 4 days a week. And then, people freaked out and said that it's not possible for the city. That would slow down the docket so much. In New Hampshire, they said, we're going to put all civil cases on hold for 1 year and just do criminal, right? Part of the issue is how under-resourced some of these systems are. And the point of them is power, right? To like reproduce power. And it's a power that is absolutely embedded in white supremacist kind of heteronational norms, right? And in this case, norms that are very deeply kind of invested in a particular understanding of conjugality, right? A conjugal couple, which is always white, which is not violent, which is not there as an object of scrutiny for care, right? That's what's being produced in this particular space. So I try to think of like different ways we can divest from it, and what other kind of spaces of repair we could support, fund, kind of hold up as models. So I'm going to end there.
April, do you have any last thoughts that you would like to share with everyone?
I would just say this has been an amazing talk, and I will add to that comment that this has been going on for decades. It's been going on for centuries and applied across communities deemed unimportant. That's how the power seems to have been created. So thank you for illuminating this in our right here, right now.
So we would like to thank Sameena and April for delivering these powerful words and insights. This was a really provocative and very powerful session. Thank you to everyone for joining us tonight for our first distinguished lecture in our 2021-2022 2022 series on emergent care and community. Please join us on Monday, the 8th of November, as we welcome Dr. Joan Silk from the School of Human Evolution and Social Change at Arizona State University. She will discuss the nexus between primate evolution and sociality, which she will highlight by comparative analysis between human and simian species. So we hope to have you back at the rest of our talks in this series and beyond. And until then, be well, be safe, and take good care. Thank you again so much for joining us, April and Sameena. Good night to everybody.